Yeah, it's good. Right, good slide.
Well, thank you very much. I think the microphone isn't on yet. There we go. Thank you very much, everyone, for joining us tonight. It's one of the concluding events of Pro Bono Week, which took place last week. And we sometimes joke it's not Pro Bono Week, it's Pro Bono Fortnight. But of course, Pro Bono is every day, so we keep the Pro Bono Week theme going. Of course, last week was really a celebration and showcasing and discussion of the role of pro bono. That is where lawyers volunteer to give their time for free to provide legal advice and representation to those in need. But we look tonight more widely at the role of the rule of law in our society, of which pro bono is an important part. So let me start, before I introduce the chair for tonight, with a definition of pro bono to set the scene, a definition of the rule of law, And that concept can be defined in a number of ways. As in previous events, we're going to use the LexisNexis definition as a starting point. And in the simplest definition, the rule of law means no one is above the law. So for the rule of law to be effective, there must be equality under the law, there must be transparency of the law, we must have an independent judiciary and access to legal remedy. And if I can develop very briefly those four aspects with these 4 points. First, all people, businesses, and governments are accountable. The law applies to everyone in the same way, no matter who you are, king, prime minister, or pauper. Secondly, laws must be clear, precise, affordable, and accessible, whilst providing those fundamental human rights. And third, an independent judiciary that ensures equality and fairness of law between people and public officials. And fourthly, accessible legal remedies. There must be access to timely resolution in a court of law. So those are the 4 key principles that LexisNexis uses to define the rule of law. I'll just add 2 quick points before we move on. If we talk about the role of access to legal advice and representation for both rich and poor, we don't have equality unless both rich and poor can get legal advice and representation in the courts. And that's why legal aid is so important. And that's why, while pro bono has an important role to play in complementing legal aid, it doesn't substitute for a properly funded or properly functioning legal aid system. And of course, one final comment, which I don't think the LexisNexis definition really includes, is what is the role of democracy in the rule of law. So with that introduction to define, at least in general terms, the rule of law, we're delighted this year to have a new chair for this now annual discussion, Paul Hodgson, who is the editor-in-chief of law.com, and we're delighted he's here to chair tonight's panel. So please do a warm welcome to our panel.
Well, thank you, Toby, for that. It's an honour to be here tonight, chairing the panel. It follows on from earlier rule of law discussions that have taken place since 2020, which was a surprise to some of you who have been involved in all of them. Didn't realise there had been that many, but this is the 4th one. We're very pleased to be joined again by Lady Hale, who you will all be aware of, was President of the UK Supreme Court and presided amongst many hearings on the prorogation case Parliament. We're also pleased to welcome back Baroness Helena Kennedy Casey, barrister at Doughty Street, who's also a Labour peer of the House of Lords, and amongst other roles is Director of the Human Rights Institute at the IBA. We're also joined on my left here by Abiodun Al-Lotikun, who has campaigned, taught and published on the rule of law, including until recently as a research fellow at the Bingham Centre for the Rule of Law. And he is a trustee for Law of Life and recently completed his training as a barrister at Matrix Chambers. At the far end, we have Roger Leese, who co-heads the business and human rights practice at Clifford Chance, where he's a partner and responsible for the firm's pro bono and community affairs programme. He also runs various charities, including Advocates for International Development. And finally, in the middle, we have Joshua Cameron, who is Managing Director at FTI Consulting within their public affairs team, and he previously worked as an in-house lawyer and a senior political advisor to the New Zealand Prime Minister, and later as a UK government advisor. So it's a privilege to have such a panel to discuss the state of the rule of law in this country. There can be few times in the modern history of the UK where the rule of law has been at the forefront of attention and discussion for such a sustained period. We're going to ask to what extent the rule of law is under threat, what those threats are, how we got to this point, and what can be done about it. And then we're going to open up the questions and comments from everyone in the room, so please pay attention and consider what you might like to say or ask when the opportunity arises. So with that, let's start with the first question to the panel. I would like to suggest, just pretend for a moment that these are not eminent practitioners within the legal industry. All these people have just been dragged in from the street. They've got no idea what is going on. They've been told that this is a panel about the rule of law. What is that? So I wanted to start maybe with you, Lady Hale, with three questions that are all related. Is the rule of law really under threat in the UK? If you can tell these people that have never heard of the rule of law what it is, and what are those threats? And what has changed since the last time the panel met 1 year ago?
That's a lot of questions. And if this really were an audience full of people who've been dragged in from the street, and I'm sure nobody has been dragged in, who knew nothing about the rule of law, they wouldn't be asking those questions. What they would be asking is, what do you mean by the rule of law? But Toby's answered that, I think. The rule of law means that we are, in this country, governed by laws and not by the diktat of individual men or women, however powerful. But it also means that the law is there for everyone. It's not just something that does things to you. A lot of the general public think of the law as being the criminal law, which does things to you on the whole. It is also an essential element which does things for you. It's there to protect you if you're under unjustified attack, and it's there to enable you to assert your rights. And it is, therefore, one of the two most essential services that any country has to have. Any country has to have defence of the realm to keep us safe from external enemies, and it has to have a justice system that upholds the rule of law. Everything else is nice to have, and of course we want it and we value it, and it is wonderful. But without those two, we are not a functioning nation. It's as important as that. So, what are the threats? Well, one of the threats is that it's not always apparent that the people who govern us understand that. They probably think of the rule of law as the rule of their law, they getting what they want from the law. Now, of course, as democratically elected politicians, they are there to make laws. But one of the problems that we face is that if we have a democratically elected government and parliament, they can sometimes procure new laws which are, in fact, deeply inimical to the universal rule of law in the way that both Toby and I have been describing it. And we have seen some recent examples of that, but an act of parliament which prevents people from accessing the justice system in order to vindicate a right which by international treaty they have, does seem an example of the willingness of democratically elected politicians to do things which are a threat to the rule of law. I'm not going to give any more examples because that would look a bit too political, but I think what I have said is agreed by a very large number of people. So where does democracy come into it is a crucial question. Should the will of the majority prevail over essential features of the rule of law? I think I've said enough, actually, but I could go on for a very long time. But I think I've probably said enough, and other people should put their oar in.
Okay, well, great, thank you. Baroness Kennedy, I know you have a lot of views on this.
Well, of course, Brenda's absolutely right, and I agree with her about the fact that it is one of those things that is so fundamental. And I remember having a disagreement with a shadow Labour Minister of Justice who seemed to think that that legal aid was part of the welfare state. And I tried to make the argument that access to justice should not be seen as being something to do with the welfare state. Access to justice, if we're going to make sure that people have representation when they might lose their liberty or that they might, in certain other circumstances, be legally assisted, access to justice is vitally important in the rule of law. And so therefore we shouldn't keep talking about legal aid as welfare, something being, given to the needy, but as something that is essential for the good running of a society. But it's very interesting that you raise the business of democracies and not democracies, because I remember when I first went into the House of Lords and I became the chair of the British Council, I went on a delegation with the Prime Minister and some people who were wanting to make business with China at that time. We're still having the same conversations. And I was there for the British Council, and we were bringing a group of people who had been trained here in commercial law. And, Chinese people who were going back on vacation, having been at the School of Oriental and African Studies and other universities where they were learning about commercial law and hopefully bits of English law that might go back with them. And we had a discussion about the rule of law, and the Chinese felt very strongly that they had the rule of law. And they insisted that when we just had a discussion about the rule of law, that they had the rule of law, that the Communist Party made the rules and everybody was expected to follow them. So the rule of law meant something quite different in some places. And the business of the relationship with democracy, I think, is one of those key things, is that respect for the rule of law is, I think, fundamental in a democracy. And you see just now, around our world, there has been something of a pendulum swing in the direction of authoritarianism. There are far more authoritarian populist governments that are nationalistic, where, run usually by, it has to be said, by fairly narcissistic men who then don't like criticism, don't like things that they want to do to be challenged in the courts. And so what they try to do are a number of things. First of all, they try to deal with the people who are their opposition, sometimes by throwing them in jail, like Putin does with everybody that is an opposition spokesperson. But the other things they do is they try to capture the media, they jail journalists, they jail the lawyers that represent the journalists, and then they go after the judiciary, and they try to capture the judiciary and to make it compliant to the wishes of those who are in government. And it's one of those things that is a real sign that you're dealing with authoritarian and totalitarian governments. But there are temptations, even in democracies, to try to capture your judiciary. And I think that you only have to look at the United States, where I think the politicization of the judiciary is a serious problem. And one of the great things about the United Kingdom, and I really do say this as somebody who from time to time has criticized the judiciary because there's not enough women or they get things wrong, but we actually have a wonderful judiciary. And the reason why is because they're not corrupt. There's no sign of corruption in our judiciary. And the independence of the judiciary is sacrosanct. And so when there are attacks upon our judiciary by politicians, it does give rise to a sense of real concern. And it's not by any one particular political party, because they can all be tempted to do it. But when you get politicians criticizing our judiciary because they don't like the decisions that are made, all they have to say is, well, we're taking it to the Court of Appeal, or we will challenge this in another court, or, we're disappointed. But to start attacking the judges and saying they're enemies of the people is a serious affront to the rule of law. to the independence of the judiciary, and politicians should be restraining themselves from doing that, but they don't. And the time when one of our newspapers, a tabloid newspaper, ran that headline, Enemies of the People, describing the judges in a decision that was about parliamentary sovereignty, it was quite shocking. And yet the Lord Chancellor, who should have been protecting the judiciary, didn't say a word for quite a number of days, and it was a great disappointment to me. But the rule of law requires certain things. And in a democracy like ours, one of the things that we have to do, and we have to, as lawyers, speak out when we see it happening, and as legal commentators and so on, we have to speak out when we see attacks being made on the judiciary, and when attacks are being made on lawyers who are arguing cases as they should, without fear or favour, on behalf of clients in the courts.
Great, thank you. Josh, could you talk a little bit about this and what has changed since last year?
Yeah, I mean, I think there's still much to be positive about in the UK on this. As has been pointed out, there are a hell of a lot of countries around the world that are going very rapidly backward in terms of this, where people are looking for strongmen solutions to every problem and have no regard for the rule of law whatsoever, and we've seen that in Russia and elsewhere. Here, the judiciary remains unpoliticised, it remains independent, it remains uncorrupt. You have whatever accusations you might make about the government, there's no suggestion it's tried to deeply politicise the judiciary in any particular fashion, although it hasn't been fast enough in defending it in some cases. Certainly some conventions have wavered, but I think institutionally the UK has remained strong, whether that be the Privileges Committee standing up to those who it's supposed to stand up to, or whether it be the Metropolitan Police saying, and I've got a great many problems with them, but saying, no, we won't shut down a protest just because you don't like it. So there are still much to be proud of in the British system. I think the motivations that drive the threats, I mean, those are evergreen and universal. People, the public, the media, whoever, see a problem, or they see an outrage and they think something must be done, and enormous pressure comes on. People say this is something, therefore we must do it. People, things like clarity, precision, access, accountability, equality, all those things that were outlined beforehand, those don't sit high in people's minds on, when they want boats stopped, or they want a protest stopped, or they want some awful murderer dealt with in a rapid fashion. And I think that kind of need for rapid solutions for something to be done is a kind of golden thread that runs through all of these problems. That runs from a Home Secretary that feels it's okay to demand that a protest be shut down, or it runs to regulatory overreach by the Financial Conduct Authority because it's worried about how it will look if it doesn't take a particular step against a particular company. So I think there's a lot that's still very positive about it here, but I think there needs to be consideration or a kind of slowing down and taking a breath when we have these problems to think, all right, what is a measured and considered and appropriate way that we deal with problems as a society, or we deal with the things that are unpopular or outrageous, that maintains all of those critical principles that were outlined by Toby when we started.
Bjorn, if I could ask you, you've written a lot about this. There's a recent report that came out by Justice, and if I could just list some of the threats that they cite as threats to the rule of law right now. Public consultations, valuable for ensuring the government considers a wide range of views and evidence, too often poorly conducted, if at all. There has been a growing legislative disregard for human rights. Henry VIII powers, which allow ministers to amend or repeal laws through secondary legislation with little parliamentary oversight or scrutiny, are being used. Cuts to legal aid have decimated universal access to justice and victims. So there's just a few of them. What are your views on where we stand right now?
Well, I would certainly echo the views of Justice. These are major consequences and issues of a rule of law culture that isn't quite engaging with the full public in the manner that it should. And I'd like to depart a little bit from what I would see as the elite conversation about the rule of law and talk about how the rule of law impacts citizens in addressing that question. So, as a trustee of Law for Life, that is the foundation for public legal education. We've done quite a lot of work around working with groups like Roma black and minority ethnic groups, to provide them with information for them to be able to deal with legal issues in their lives. And we found that there's quite a significant gap between the public's understanding of the law and where the elite decision makers think they are, such that some reports have suggested that up to 1 million civil claims aren't brought each year simply because people don't know that they've got a legal problem. And so one of the solutions that Law for Life and others have sought to effect in this space is to increase the public's knowledge, skills and confidence to resolve and tackle legal issues through public legal education. So we were involved in a piece of work with the Solicitor General. We set a 10-year vision for where we wanted England and Wales to be in terms of the public's understanding of the law. But it seems as though in the intervening years, it hasn't quite had the level of traction that we would have sought, and it hasn't quite been as much of a political priority as we would have thought. And I would certainly echo Justice's views that it seems as though the public consultation is increasingly and still a vehicle for academics, politicians, lawyers to contribute to the public conversation. But what about our kids in Hackney who aren't being able to be privileged consultees when policy is being formed that affects them? So we've seen a few really interesting and I think useful models for how you go about bringing citizens into discussions about how you improve the rule of law. Recently, the House of Commons Justice Select Committee ran a public inquiry into the public's understanding and opinions of sentencing, and they used the charity Involve to get a series of stratified representatives of the public from all walks of life to first inform them about sentencing policy and then to ask them how they would change and improve it. And to me, that's a really useful model for how public decision makers can involve people in how the legal culture can be better serving of the rule of law across different parts of society. And again, as someone who himself is from a group that isn't traditionally involved in the formation of public policy, but through my career have had the opportunity to do that, I would like to see more people like me around the table when these decisions are being crafted. And the idea that there are groups that are often not involved in the formation of policy, yet policy involves all of us, I have always thought is a key aspect of inequality before the law, where some groups are simply not involved. So I would like to see much more widespread use of very participatory forms of consultation, going into community centres and the groups that are furthest away from Whitehall when legislation and whatnot is being formed. So they're just a few ideas, and very happy to feed into the rest of the conversation.
Great, thank you. Roger, could you talk to us a bit about why you think we've got to this point? What are the pressures that are driving this? Is it just a few bad actors in the government, or is it actually something broader in society that the government's reacting to, do you think?
Thanks. If I may, I'll just come on to that in a second. And I would just also, just one observation hearing the rest of the panel here, which is, you know, the rule of law and its meaning is not monolithic either. It does have very different resonances depending on what you're talking about. And you know, in this way of talking about it, which is about, if you like, our politics and how our institutions work and how the country works, if you like. I think that is very important. It just resonated. People were talking. I just read an article by Andrew Marr in the New Statesman this week, and he said what's really lacking in our politicians at the moment is a lack of any effective narrative about what we are as a country, what we believe in, and what we're looking to achieve. And it does strike me that, you know, we should be arguing that the rule of law is part of that, something that we're losing, and something that should be absolutely part as to how we see this country and how we function, and how it strengthens us as a people, and that understanding and that belief in the rule of law, that political level. But coming, if you like, to your question to me, though, which is looking at the rule of law actually from a very different angle, and I see it, I suppose, with, you know, a couple of my hats on. I'm on the board of the Royal Courts of Justice Citizens Advice, which in particular offers advice to litigants in person, a lot of other things, but offers advice to litigants in person in the High Court. I also, you know, actually, as you mentioned, I'm responsible for the pro bono work that we do at Clifford Chance, which involves a lot of work with law centres in particular. And what I see through those interactions and from talking to people is the real issue, and this is, if you almost, this is the death of 1,000 cuts, quite literally, that have gone on, not even post 2010, but as long as I've been a lawyer, it's an awful long time, which is that, going back to the conversation, the rule of law and the access to justice, can I now talk about it as access to justice, has just not been a priority, has not been seen as something, just as Helena said, you know, just as not seen as something that's particularly important or it's just part of welfare. No, it's not. Access to justice is the bedrock of a decent life in a decent society. And from my engagement with litigants in person at the High Court or people, you know, coming to advice centres, this isn't about, often it's not about them being locked up even. This is about housing. This is about small claims. This is about problems with the neighbours. This is about the day-to-day of people's lives, and which are actually governed by our rule of law, by, if you like, fair laws and so on and so forth, contract and tort and all those sorts of things. And most people do not have access to any advice at all. And it's, so far as I can see, we ought to be making the case that for citizens, you know, knowing where to get advice as to what to do about their debt issue and their contractual issues and their housing issues is every bit as important as going to the GP. But we just don't have that culture here, or we've not managed to build it. And that's really something that we need to do. But the money has to be there. I mean, you know, as a pro bono and lawyers, we do quite a lot. But even when we're providing advice pro bono, we need an infrastructure. There needs to be a Royal Courts of Justice advice centre. There needs to be a law centre. There needs to be supervising lawyers who actually get paid a living wage. And that isn't the case. So you cannot do this without money. And you know, we need to put our money where our mouth is. Now, this government, and actually UK governments in general, express a great deal of pride about you know, this country and the rule of law. With Advocates in International Development, we actually run the government's Rule of Law UK programme, which funds a lot of programmes working in Commonwealth countries in the main on rule of law issues. We feel this is an important part of who we are, and yet we don't put our money where our mouth is and provide people with access to advice, which so many studies have shown actually saves us money in the end. If people's problems could be solved at that level, it doesn't end up with them in the, you know, taking up time in the courts when it needn't have got to that stage. I'll stop there.
That's great, thank you. Lady Hale, what are your thoughts? Is it all about funding?
Well, funding is a very important aspect of it. I agree, of course, with everything James has been saying about the need for proper legal advice and help. It's the phone call, it's the email, It's the letter that solves a problem long before it gets anywhere near a court.
Absolutely.
Really, really important stuff. But also, we do actually need courts. Yes. I think that's worth saying, isn't it?
It is, yeah.
Because the number of courts that have been closed. I mean, I come from North Yorkshire, really rural part of the world. When I grew up, there was a magistrates' court in my village. Well, they closed that. And so we went to the nearest town. And then they closed that. And then they went to the county town, which was really difficult to get to, but at least it wasn't that far away. And then they closed that. And there are now only about 4 magistrates' courts in the whole of North Yorkshire. This is ridiculous. And then, of course, they've artificially closed Crown Courts by restricting the number of days that they could sit, which is one of the reasons why we have this disgraceful backlog in the Crown Courts at the moment. It was pre-COVID, and of course COVID made things a lot worse. I could go on. The state of the court, some of the courts that remain, is a disgrace. So we do actually need courts, and we need judges, and we need the people to staff the courts as well as all of that.
So are you saying because the courts aren't in people's consciousness in the same way, that it sort of undermines the idea of having them?
Well, I think it undermines rather a lot of things. Who is going to bother to prosecute a theft that takes place in Swaledale when the nearest magistrates' court that, unless we go out of county, which I think would be a very good thing, is actually in York, which is a million miles away and really very difficult to get to. Who is going to take a small claim when the nearest county court is inaccessible? Who is going to seek a remedy for domestic abuse and violence? And let's not forget that's a rather important area of equality and access to justice. If you can't actually get to the place that will give you the remedy. I do from time to say that one of my solutions to this would be a justice bus. And what I mean, and they have them in other parts of the world where they have, large distances and so on. And basically, you would have a mobile unit which contained the usual courtroom sort of setup, but rather less grand, but it would have everything that you needed in there, and it would have a district judge, and it would have a clerk, and if it was going to do some crime, it would have a prosecutor, and it would have lawyers who are also there, and it would tour around and park in the marketplace, and then people would know about justice. It would be there. Rather than having these various campaign buses that have slogans on the side, it would be the justice bus. Now, I know this is pie in the sky, and I know it will be regarded as a joke, but actually, I don't think so. I think it's something that could really make a big difference.
I don't like it. I think it's a terrible idea.
I thought you'd say something like that.
Listen, only a year ago, the International Bar Association gave an award to a man in Malaysia who set up that sort of thing, it was a legal advice bus, which went to villages and so on, and where workers were being exploited and horrible things were happening to people, and they got terrible injuries at their work, and they never got compensation and so forth. And he took this bus around, and it was a legal advice bus. And I'm all for having a legal advice bus to go to places, so take it to the people. When I started at the bar, there was a thing that used to happen for solicitors, which was a green form scheme, which was that somebody could go in off the street and get advice about something. And it made me think of my mother. When I was a child, my mother, we were living in a pretty disadvantaged part of Glasgow, and my mother's running to do shopping, and a slate came off a tenement building and came down, and it split her head open, and she was almost blinded. And she was mended, and then the question was, she went to the hospital and so forth, and then people said to her, May, you should get a lawyer and sue them, because that building has been neglected, and the landlords have never bothered to keep the roof in repair and so forth, and somebody should do something about that. And my mother, I know that I heard the discussion in our home, didn't want to go to a solicitor because she was frightened that it was going to cost her just to walk into a solicitor's office. And that's what an awful lot of people, the people that you're talking about, feel. They feel, are you sure that I would have a claim? But if I went in and I spent time with them, they might give me a bill and I can't afford it. So the green form scheme was to deal with that, and it was just basically an hour of advice was available to people who had a legal problem. And I think that should be reintroduced, because I thought it was some of those good things that used to exist actually are worth revisiting. But a judge from the United States once said to me, you in Britain have a legal aid system that, you should be proud of. It's such an incredible system. We don't have that here. And it's very hard for people to take things to courts or to be properly represented in courts, etc. He said, but I tell you what we do well, and that you don't do so well, is, he said, you did in Victorian times, but we build beautiful courts that say to the society, be proud. This is a society built on law. We have a legal system that we care about. And the courtroom in every town had meant something. And those old magistrates' courts that you've been describing were lovely old buildings. They're now blocks of flats, probably, charging a ton of money to people to buy them. But I do think that that not having proper courts for hearings so that people feel respected and that there's something serious going on there. Why should people feel that? Certainly they wouldn't feel it if they were in a bus. And so I want people to feel. Yes. I want people to feel that they're being treated with respect, and that they're getting a hearing, and that they're being listened to, and that it's a proper process. And at the moment, that's not possible. On Friday, I was only just telling Lady Hale, I went on Friday morning up to do the keynote address to the Association of Women Judges up, and it was taking place in Birmingham this time. And I went up to do that, and there were all these fabulous women. That's one of the great things that has happened, is that there's diversity in our judiciary, which wasn't the case when I came to the bar. And these fabulous women are all there. And it was really awful hearing the description of life as a judge at the moment, with backlogs of cases where they're under huge pressure, where they don't feel that they can do the right thing because people are not well represented and often are not represented at all. And the description of this, and in leaking courts where the lavatories are blocked and where the whole system is not working. And it's been because of the austerity, I know we're supposed to be above talking about politics, but if you introduce cuts to the Justice Department, which happened in the austerity drive after the economic crisis of 2008, and it was visited on the justice system more than any other government department. 25% was taken out of the Justice Department. That was volunteered by Chris Grayling. I mean, Chris Grayling, as far as I'm concerned, is somebody who should be in the dock for the things that he did to the justice system. And the probation service was destroyed. So how can you have alternatives to prison if you haven't got a good and decent probation service? And you can't create alternatives to prison. And you can't review people who are coming out of prison and help them to reestablish their life in the community. And if you haven't got people who are advising the parole board and so on, is it any wonder with the system's in the mess it's in? And I'm afraid it has been ideologically driven. Justice isn't important because people don't vote on the basis of the justice system. That's how it's seen, and that's why we should be concerned about better policy initiatives. Okay?
Hooray. And could I just add one extra thing on the money as well, is of course the other place where there's a massive squeeze as a result of, I think it goes back further than austerity, of course, but austerity also massively squeezed local government. And local government was largely responsible for actually funding grassroots legal advice in legal advice centres and citizens' advice and so forth. That's where their money came from. And it got to a situation where the pressure, I was being told one story just the other day, that one local government was resisting giving any additional assistance to a law centre because they say, but you're advising people about their housing rights and we've not got the money to deal with the housing rights, so we don't want to fund you to give them proper advice as to what their rights are. And of course it's explained, actually we're on the same side. This will help save money, etc., and save people's livelihoods and so on and so forth. But that was another, people don't realise just how much of the money from local government was going into access to justice, which went.
Yeah, I get it.
Yeah, I just wanted to come back to, I suppose it's the implication from Justice Bus, Legal Advice Bus, which is a lot of people just want justice where they are. And for a lot of people who may be considered hard to reach by the justice system, I'm thinking particularly of Law for Life's work with Roma and Gypsy traveller communities. You can't just go in there as a solicitor or a barrister and say, this is your cause of action, this is where you go, and be believed and automatically trusted. For a lot of those people, it's often more effective to work with what we call a trusted intermediary group. So that may well be an existing Roma or traveller charity that works with them, who have an established relationship, who know what the best ways are to encourage and inspire them to take action on the legal issues that they face. So at Law for Life, we've been doing quite a lot of train-the-trainer activity, where we have 25 Gypsy and traveller advocates who we've provided courses for in how they can then be the referral to the citizens' advice or the other legal organisation that might be the first point of contact for someone with a bit more trust in the legal system. And we found that through that approach, there's a 50% increase in their ability to be able to deal with these issues and a 30% increase in knowledge. And I think the point is, lawyers are not always the best people to go directly into a community to say, these are your legal rights and this is legal empowerment. But often it's about existing organisations who already have that relationship being the best route in to helping people who are disadvantaged or vulnerable.
Yeah. Josh, can I ask you, do the public get it? Do they understand what the rule of law is, why it's important? Do they even care?
No, perhaps not. As Baroness Kennedy pointed out, people don't tend to vote on justice issues because it's not something that in their day-to-day they conceive of using, whereas you conceive of using the health system because your granny just got a hip replacement, or your dad got cancer treatment, and you conceive of the education system because you've been through it. A lot of the public, obviously not those people in this room, but a lot of the public don't conceive of using the justice system and don't see the plumbing, don't see it as the plumbing that makes society function and that makes transactions and contracts and all the little bits in their day-to-day life possible. And I think maybe, in true British fashion, I say this as an immigrant, the profession has been a bit bashful about talking about its own importance. And the concept of the rule of law, I spoke about this last year, that the idea of the rule of law being something that can be proudly said to be a British export. Perhaps the greatest thing that Britain has given to the world, you could argue, is the common law, and I certainly would argue is the common law and this notion, because if the Greeks invented democracy, I would say that this is the birthplace of the notion of an individual's right to some of these concepts of access to freedom, to access to law as we understand it. And I just wonder if there isn't a scope out there. People aren't going to just, we can lament it all we like, but people aren't going to turn around and go, you know what, it is important that the guy 3 doors down has access to the legal system for that dispute over his employment thing. No, they're going to keep on voting on healthcare and cost of living and various other things unless you go out and make the case for why that's important. That justice is something made in Britain, and it's something to be proud of. It's a very British thing to be proud of and be patriotic about. And I think there's a tendency, for all sorts of reasons that I understand, to be very bashful about that, as the history of colonialism and the history of injustice and all that. And I get it, but there's a reason that people come here to solve their disputes. There's a reason that they use English law as their dispute resolution mechanism. There's a reason this is the centre of alternative dispute resolution. And that is something to be proud of, and I think the profession as a whole is to be less bashful about that.
Lady Hale, it feels like the British legal system is better respected in other parts of the world than maybe at home.
Almost certainly. Yeah, that's absolutely right. And maybe we're not very good at blowing our own trumpet about it. And perhaps we should. I'm grateful to you for saying that, yes, that just possibly it's something we should be proud of, and I think it is. I actually think, of course, and this leads on to something else, that the basics should be taught in school. I'm all in favour of public education, but I actually think education starts in schools.
Absolutely.
And whereas there are other countries in the world where primary school children do know the basics of how they are governed, including the importance of the justice system and the role of the justice system, and we don't seem to do that in this country. Nor do we teach the history of the 17th century, which we seem to teach the Tudors millions of times, and the Second World War a few times. So a few episodes get double treatment. Nobody goes the whole way through 1066 and all that, which is a great shame. But the one thing that everybody should know about is that we had a century in which we had a rebellion. We killed our king. We decided, actually, that we'd better have one back. But when they were a little bit naughty, we kicked them out again, or treated them as having him, James II, as having abdicated, whether he had or he hadn't, and got back monarchs on terms. A constitutional, wasn't a democracy then, but definitely a constitutional settlement where the king wasn't in charge. It was on terms. Now, everybody ought to know that. And that includes certain people who've been leading this country, in recent terms. You have power on terms, and that's the crucial thing about the rule of law. And I do believe we ought to try and teach it in schools. I don't think it's difficult.
Well, children know immediately about fairness.
Oh, yes.
And when something's not fair, they know it instinctively.
They've got a great sense of justice.
They do. Can I come in on something, which is that I agree with Josh that, it is very interesting to me the extent to which Britain and our arbitration system and our courts are often the place of choice for resolution of potential commercial disputes, so that when a contract is drawn up, I remember I was once involved in a case for a Swedish trade union that had invested with an American bank, but they had chosen the British courts to be the place to resolve any potential dispute. And potential dispute there was, let me tell you. But it was so interesting to me that here were the Swedes and the Americans, but they were choosing the British courts for the resolution of any potential dispute. And why? Because they trusted our judiciary, because they know that we have a good legal system, and so on. And they also know that we have very good lawyering. But I always say that the law, sometimes you'll have that discussion with commercial lawyers, and they almost feel rather grandly as though what happens in the lower end of the courts is nothing to do with them, and so they feel backlog of criminal cases, that's not my business, and so on. And the law is a tapestry, it's all of a piece in it. And once you start destroying parts of it, it starts impacting on others. And reputationally, if we are not seen as a place where proper trials are taking place, where there isn't a huge delay and so on, as they have in Italy, for example, if we start getting the reputation for being bad on these other areas, it will impact on how we're perceived in relation to those grand commercial cases. And I want to mention one other thing, which is that a lot of my work just now has become international by virtue of running the Institute of Human Rights for the International Bar Association. And the International Bar Association is very largely a commercial lawyers' organization. But they care enough about what happens around the world. And one of my roles is very much to be on the lookout for the ways in which judges can be under threat in countries around the world, and that there should be some solidarity amongst the lawyers of the world and about protecting judges, about protecting lawyers under threat in places. And we speak out about human rights abuses, of course. But it's very difficult to complain about things that are going wrong in Hong Kong, where there was a sign of a Chinese-British treaty that was signed in the late 90s, which was guaranteeing that there would be respect for the rule of law and the system that operated within Hong Kong. And we're seeing that being eroded. But it's very hard for us to complain about breaches of a contract, breaches of a treaty between China and Britain, when we're breaching international treaties ourselves. And we are. We're doing it we've certainly been doing it, and we were doing it in relation to the end of Brexit, where we signed a treaty with Europe on the exiting, and then and the basis on which we were out, and the protections that there were in relation to Ireland, and then we were prepared within a year to tear it up. Well, how can we be respected as respecters of law, that thing that we proudly should be boasting to the world about? Well, let's not raise our heads above the parapet at the moment, because we're about to tear up a treaty that we signed less than a year ago. So, we've not been behaving that well. The business of the Refugee Convention, giving protections for asylum seekers, and we're playing fast and loose with that. So, you've got to not speak with forked tongues if you're going to be boastful about your system, and that's one of the things that I really feel is important. I am proud of this system, but I'd like us to be true to it.
Yeah, I'd like to pick up from comments that Baroness Hale made about the young people and their receptivity, awareness and ability to understand the rule of law. So in 2018, whilst I was at the Bingham Centre, I founded something called the Public and Youth Engagement Programme. That was basically an attempt to get Lord Bingham's principles, his 8 principles for the substantive human rights facing rule of law, and get it into as many schools as possible. And I'll give a sort of twofold suggestion. It doesn't work, but when it does, it's brilliant. So we have this thing called the national curriculum. One of the subjects within it is citizenship education, and in Key Stage 3 and Key Stage 4, people are supposed to learn about international law and human rights. They're supposed to learn about how Parliament works. They're supposed to learn about their rights and how the government, whenever there is an act of bad faith or illegality, is supposed to be judicially reviewed. Jobs are good and complete? Not quite. There have been a lot of changes to the structure of schools across England over the last 12 years, whereby many schools have become academies. That's great from a freedom for choosing your subjects on the basis of your local needs, etc. But it's terrible for making sure that everyone is learning about the rule of law. And so there has been this reduction over the last 12 years, whereby many schools that previously had some kind of provision for teaching about the law, and specifically the rule of law, have deprioritised it as they no longer have to do it. So it's been a space that voluntary organisations, Young Citizens, Law for Life and others have sprung into to create these sorts of initiatives. And at the Bingham Centre, we've been working with a bunch of ambassadors who are largely lawyers at the start of their career and students to get them to get into classrooms to teach children in schools about the rule of law. And it works brilliantly. You know, as Baroness Kennedy's already said, young people and children have an instinctive sense of injustice, and once you say, how did you feel when there was a school rule that said this is when you get a detention, but the teacher didn't follow that? How did you feel then? Then they start to get arbitrariness of decision making. Then they start to think about, oh, actually, maybe I'm going to launch a judicial review here. And it's that space in which I think there is a really sort of effective age, you know, that 14 to 18 age where young people can actually understand the law, and they're still in that sort of rebellious area where the idea of being able to challenge an authority figure is something that's interesting to them. So I think there's tremendous work being done by organisations like the Bingham Centre and Young Citizens in this area. I just wish that there was a more binding and holistic requirement for young people to learn about the law. Because in the words of the Ad Hoc Select Committee on Citizenship and Civic Engagement in 2018, this area has been enabled to degrade into a parlous state, a situation that in their follow-up report in the next parliamentary session was exactly the same. So that's where we are in teaching young people about the law. In some places it's great, it's patchy and piecemeal everywhere else.
We've talked a bit about these kinds of issues and some of the democracy issues. What we've not talked about is the effect on business and investors. Well, Roger, that's your world. What would you say to that?
Well, I suppose I would pick up on what Helena was saying there, but sort of maybe just explore a bit and maybe turn it round slightly. So, you know, I'm sure there are lots of commercial lawyers out there. You know, well, I know a few of them, I guess, for whom these sorts of issues we're talking about tonight, they don't feel are particularly relevant to them. But what I would say is, well, I suppose splitting down to a couple of things. So far as the, you know, commercial law firms, at least in, you know, London are concerned, you know, I think en masse, and I'm not sure there was a single firm that commented on the LASBO reforms years ago, didn't say this is completely bonkers and we think legal aid is essential as a bedrock of our society. And that is the position of the commercial law firms. At least at that sort of level, institutional level, we absolutely get it and recognise this issue and recognise the backlash against lawyers in general as well if this isn't got right, and if people don't buy into the fact that rule of law and access to justice is something for everybody and matters to everybody. And we're saying about why don't people care? Well, they're not going to care if they've got no opportunity to use it because they can't afford it. So it's not like, because they can't go down to like they go to the GP for the hip replacement. They can't just go down and get some legal advice on their employment contract or whatever, and actually get the litter. You were saying it's not just about the advice; it's about doing something about it, and that's where we come in. But people need to be paid to do this. You know, that's what gets missed. But absolutely, one of the reasons why, though, to come back to the question, because law firms absolutely do get the privileged position that we in the UK, in particular the London law firms, have in the world as the second biggest law centre in the world, is because of that perception from business that English law and the dispute resolution process through the courts, it is actually superior to just about everywhere. And actually, when I have this discussion, I always go back to a situation I had quite early on in my career, quite a long time ago now, where I had an international case, and I was a relatively junior lawyer, and me and lawyers from a couple of the other countries that were involved in this dispute were just sort of having a chat about where would, from our client's point of view, who we believed had the right, was in the right in the legal analysis, where would we want the case to be heard? I was the only one who said I would be confident that if we were before the High Court in London, we'd win. The others were not, because they didn't believe their system would get to the right answer for different reasons. But that's always remained with me, of the sort of confidence that we can advise our clients that, in general, you will get the right result here. And that's invaluable. That's invaluable. And investors and business gets that. But the translation, and actually translating it, does government get that we need the whole tapestry, as you put it, Helena, to work? I don't think they do. And again, you know, partly our fault as well. Are we speaking up enough? Or do people care what we say anyway? Maybe another cynical thing to ask. You know, we will see.
So Lady Hale actually has to leave us. She's got another appointment. She's been very gracious in being here, but she has to leave in 5 minutes. So could you talk, Lady Hale, for a little bit about where we go from here? What solutions there are available? What things you would like to see? You've talked about a few ideas already. What would your final sort of advice be? And what can people in the room do as well?
Well, people in the room can keep up the good work that you already do, but also fly the flag, both for the justice system here, for the need for good legal advice and help, and for the need for courts. I mean, I would have both a justice bus and a legal advice bus side by side, because I think, unfortunately, we're not going to get these lovely new courtrooms. So I think I'm being a little bit more practical, really, perhaps. And I also think the whole legal education thing is really key to it. There is no reason why certain things should not be an absolute minimum in the education system, not just a nice to have. And I think this must be our slogan. Law is not just a nice thing to have. Actually, it's something that we've got to have, all of us. And we've got to keep on getting that message across. Maybe, oh dear, ought there to be more lawyers in Parliament? See, in the olden days,
There used to be a lot.
there were loads of lawyers in Parliament. And it meant that certain of these issues actually people got. But there are now remarkably few lawyers in both houses of Parliament.
That's right.
Not just in the House of Commons, but also in the House of Lords.
Well, we've got a lot of elderly judges who come into the House of Lords.
You don't have a lot. You don't have a lot.
Well, I mean, listen. It's a great benefit.
Sorry, I'm off now. But this is not because we disagree. Actually, Helena and I agree about virtually everything. So this is all a setup.
We have to always have a little bit of a thing.
Yeah, this is just making things interesting for you. But I'm sorry that I can't be here for the Q&A, because that's always much more fun than hearing us spout off about things. But I'm sure that everybody, well, there'll be people on this panel who give the same answer to the questions that I would give, so I have every confidence. And forgive me, I do have to go, but enjoy the rest of the...
Can we give Lady Hale a round of applause? Helena, you were saying?
What was I saying? I've forgotten what I was saying. Well, I mean,
I do think that it is vitally important to have politicians restrain themselves. And I have been particularly distressed, and I know that the Bar Council has come out about it, the Law Society has come out about it, but to hear politicians in the Cabinet speaking about lawyers in derogatory terms and being dismissive of lawyers and you know, really in ugly language is totally unhelpful, because if we're talking about trusting and trust to win trust from people, then you're not helped when people are saying that you're a shower of shysters and that you're all mad left-wing lawyers, or you're all in it for the money, or you're all corrupt or something. I mean, there's something that is precious about this, and once you get that sort of denigration being made by politicians, then I think it's very alarming, and I think that there should be a great deal more restraint. But one of the things that I did want to say is that, and it's just a beef of mine, and I'm going to give it to you tonight, I think a serious mistake was made by not the present government, but by the previous government. I mean, by the previous government I'm talking about when Labour was in power. It reformed the role of the Lord Chancellor, and it combined it with a Justice Minister's role. So, and not only that, but they decided that you didn't have to be a lawyer to have this role. So, you could be any, law can be as alien to you as you like. But not having someone in the cabinet who's been a practicing lawyer and who knows and understands the law and why it's so important, to be the champion of the law and to be saying, hold on a minute, and to remind people that protecting the judiciary, protecting the independence of the legal profession, that those things matter. I think that is a great shame. And I think that it's been a retrograde step combining the two. And I would like to see the role of the Lord Chancellor reinstated, and that there's somebody who actually speaks to the rule of law in the cabinet. Because I don't think you can combine it with the political role of being a policy maker, being the person who's running the court system and running the prisons and sentencing and all of that. I really do think that the role of the Lord Chancellor should be reinstated with that significant thing of being a listener at the cabinet table, but who reminds people of the importance of the rule of law.
I think you said before that in the past it was someone near the end of their career who didn't have political ambitions. Which is quite important, isn't it? Because they're not trying to get an edge, they're not trying to gain a new position.
Absolutely, and they're in the House of Lords, so they're not wanting to be the Prime Minister, and they're not being populist and wanting to get the tabloid newspapers saying good things about them. And so you don't have that. And I really feel that it would be a good thing to return to that particular function. I mean, I was all for modernising it because I didn't think it was right that someone who was sitting in the cabinet should be also sitting on the bench as a judge, which used to happen in the old days. I didn't think it was right that all the appointments should be in the hands of the Lord Chancellor. I like the idea that we've got an appointments commission, which does very well in the business of appointing judges. So I really just think that it's that business of speaking to this very thing that we're talking about tonight. And I don't think it should be in the hands of a practicing politician. What do you think?
Well, look, I think it can go further than that, really. I mean, back in the 80s in New Zealand, they passed a Bill of Rights, which has all those nice things in it: equal treatment under the law, access to justice, free speech, all of that. And it has ever since been the role of the Attorney General to stand up in Cabinet and make those points, but also before Parliament passes a law which breaches the Bill of Rights, and Parliament can do that because it is sovereign, the Attorney General has to stand up and say, this will be a breach of the Bill of Rights, we will be breaching this law we passed back in the 80s, we will be undermining access to justice, we will be taking it away from someone, we will be abrogating someone's right to free speech, and Parliament still does pass those laws and still does take those actions, but there's nowhere to hide at that point that you've been told that this act, whether it be after a disaster or during COVID or whatever it might be, that it is a breach of these fundamentals. Now, and
that would change the role of the Attorney General in our system.
Exactly. This is more of an equivalent of a Lord Chancellor. Smaller Parliament, we don't have so many people. But you could do that, Lord Chancellor doing exactly that, standing up and saying, even if you don't have a formal Bill of Rights for this, here are the basic agreed upon principles, and this, Parliament, if you are going to take this step, you will be reducing access to justice, and this is the formal advice, and you put it on if necessary, on a statutory basis. This is the formal advice that the Lord Chancellor must provide before these things can be voted on. And so that the courts indeed get that signal that, well, it was the intention of Parliament also to ignore.
I think that separating out is important. I mean, for example, in the Indian system, the Attorney General is not an elected politician at all. And so though it's the Attorney General who does it, they don't have a Lord Chancellor, they don't have a House of Lords, but they do have somebody who is standing apart and is not dependent upon winning the votes of an electorate. And I think that was a mistake when that was done.
It's usually someone unpopular
Okay.
as well.
So it'd be great to get some questions and comments from the room. We have a hand up over here. We have a roving microphone. So if we could come to this side first. And then we also have some questions from online who we'll draw on as well. So if you're interested in asking a question, do shoot your hand up before we go online.
Good afternoon.
Yeah, it's on. It's on.
Hello? Yeah, here it goes. Yeah, this is an address to all the panel. I come from a legal family, and I'm very distressed about the elephant in the room. When I say it, the elephant in the country. Everyone objected to proroguing Parliament and anything to do with Brexit and other aspects in society. One of the greatest abuses of the legal system and the way Parliament behaved, particularly the Health Secretary, was over the COVID pandemic. They brought in draconian laws where lockdowns, which basically, my wife's Polish, resembled martial law, and brought in rules about vaccine passports. So frankly, the biggest violation of our civil rights in hundreds of years. And where were the legal professionals then to stand up for our rights?
Who would like to take that?
Well, I mean, funnily enough, there were debates certainly in my house, in the House of Lords, about where the excessive, where was the oversight of this, and it's a pity you didn't ask your question while Brenda Hale, Lady Hale, was here, because she has spoken about this. Certainly, when we were here last year, it was one of the things that she mentioned was that she felt that was done as an executive. It was done on an executive order. There was no parliamentary oversight of it, and so she was very concerned about that power grab. And it's the same thing. We've just lost Lord Judge, Igor Judge. He just recently died. And Lord Judge was one of the people in the House of Lords who was always complaining about the fact that there was too much power grabbing by the executive, by by government, the ministers and so on. They've got all the power, and that they're not being held to account by Parliament because it's of the way in which it's been done. It's called Henry VIII's powers, and also that there's been a reduction of judicial review. So I'm afraid it was like emergency powers that were brought in, and they were not scrutinised by Parliament.
And at the time, there was and still is a lot of activity at the Bingham Centre on these issues, where recently with Sir Jack Beatson, a non-statutory inquiry has been committed into looking at how or if the rule of law may have been breached with the healthcare protection coronavirus regulations. And colleagues at the Bingham Centre continue to write and speak about these issues. And I think members of the audience might recall an event that was chaired, I believe, by Mr. Rosenberg, who's just left, involving Lord Sumption. That was at the time, again, another critique of those laws at the time. Again, that's available on YouTube for those who are interested.
I completely agree with you there. I think whatever we might think of the rules that were passed, I think the problem was when you have a government saying this is a massive emergency, we must all do X, and you have an opposition which isn't really objecting to that, and you have a media which is also going along with it, it becomes, and the courts are shut down, it becomes quite difficult to do anything about that. But just returning here, taking the opportunity particularly to return to Baroness Hale's point about, who does populist things and what have you, which governments do them. I was the only country on earth to ban, during the COVID virus, ban its citizens from returning to their home country.
You're New Zealand, yeah.
Yeah, it was New Zealand. So that wasn't done by Hungary's Viktor Orban, that was done by Jacinda Ardern, who a fifth of New Zealand citizens live outside their country. And for 3 years I was forbidden from returning to it, and there couldn't be a more fundamental breach of a citizen's rights, I would think. So yeah, the urge towards populist draconianism in a crisis is one that we always have to be wary of, and that the profession and the justice system have to have a major role in fighting. And I don't know that anyone covered themselves in glory, frankly, during the whole COVID crisis.
Let's get another question from the room, then we'll get one from online. We have one just at the back here, if we could.
I think we can all agree that the people who least covered themselves in glory were those who thought they were above the law.
Oh, yes.
Hello, this is on, I can hear myself. Two questions about more public engagement in the law. One, in the Republic of Ireland, which I declare an interest in because I have dual nationality there, they had a very successful round of citizens' assemblies where they finally got round to modernising the law on abortion. So they got rid of the constitutional prohibition on abortion. So my first question is, should we engage in more citizens' assemblies to get people who sort of overcome the whole disengagement in, or problems with engaging in consultation exercises? The second thing is, and I think I can guess the answer to this, we need more law centres, because I come from a rural part of Essex where my nearest law centre is at most a half an hour bus ride away from me.
You were going to go on.
Oviedo and then Roger.
Yeah, certainly. So this is something that I don't think has attracted as much public scrutiny or public reminders as it deserves. But there was a big element in the 2019 government manifesto where they promised a Constitution, Democracy and Rights Commission that would look at elements of the UK Constitution. And though many have considered that by stealth to be sniping attempts at the Human Rights Act and other elements of our current constitutional structure, I've written elsewhere that actually represented a really big opportunity to consult widely and broadly with diverse groups of citizens about what our constitution could look like. And I think one of the vehicles that people at the UCL Constitution Unit have suggested for doing that is the Citizens' Assembly. So you'll certainly find a fan of that here. And in terms of geographical spread of law centres, I think there's a really big problem with legal advice deserts, where in some areas of law you don't have a public lawyer, a housing lawyer in your area, which again is a big matter of the inaccessibility of justice for a lot of people. I've lived in cities all my life, never had that problem, but it's a big issue for people in suburban and rural communities that, again, leads to patchy and piecemeal provision of people in dire need of some legal assistance. So, again, I'm completely on board with that suggestion.
Roger.
Yeah, so yes, I think it's certainly, answering the second question first, the answer is yes, certainly more access is needed. There are a number of ways that can work. As I said before, I think there's just the basic availability, though, of suitably qualified social welfare lawyers. Just to give you one example, the City of London Law Society is now supporting a fund to help pay the legal costs of social welfare's qualification because their own law firms cannot afford to pay the costs of training up and the sitting of exams by their legal execs and so forth to become qualified. And, the CLLS is having to raise money and has raised £500,000. It's great and they're supporting, people through that education. We're in a situation where social welfare lawyers their law firms can't even pay for them to get qualified. We're in trouble. On your first, it's a really interesting question. It's back to the whole consultation thing, which we could certainly spend a lot of time talking about. Because, as was mentioned at the beginning, I do quite some sort of business and human rights work, and the role of consultation and consent is very important there. But what you learn quite quickly is it's very important how consultations happen, who's involved, how all the voices are heard. And actually, having gone to a lot of sort of sessions which are sort of consultation on X, Y, and Z, and then everybody says everything, then somebody says, "Oh, right, it's up," and say something which nobody in the room said. I'm a little bit, I think it's great, should happen, but an awful lot more needs to be done than saying, let's have, meetings up and down the country and simply, make up what we think we want to hear.
I'm keen to get as many questions in as possible, so we'll jump to the next one. Let's get one from online, and then we'll get another one from the room.
Hi, thanks very much. Just to say that we've had many questions from the audience online tonight, so thank you very much to everyone online. I'm going to ask you a couple of questions. So the first one is, to what extent is a uniquely British issue? Which countries are doing well and what can we learn from them? So that's the first question. And the second question is, how can we then rebrand justice and the law? Thank you.
Okay, so to what extent is this a uniquely British issue, in which countries are doing well and what can we learn from them, and how can we rebrand the law?
Well, let me have a go at this, because I have now being very much involved in an international organisation where lawyers from all around the world come together. And one of the things is that I think that it's so much easier to compare other common law countries. I mean, let's be fair. It's much easier. And, you know, Canada has a pretty good legal system, and so does, I mean, it does tend to go hand in hand with well-developed democracies. And so I think that I once did a radio program which was looking at did capitalism thrive better under a common law system? And to some extent it could be argued that that's true because of its flexibility and its ability to change. So Australia, I mean, by and large, a good legal system. I mean, ask the Aborigine folk, and they would say to you, is it hell? But, I mean, you know, they're all, you know, we're not talking about perfect, and I don't think that you can find any perfect system. But I think that, the systems that I know about best, of course, are common law systems. But there are common law systems, or places that inherited the common law system, that aren't so terrific at all, and that are, you know, really, you know, we can't pretend that it works everywhere. The other thing is that, I mean, let's, for example, there are lots of people who think that investigative systems, like they have in the civil law systems, are a great improvement. Well, they are for some things, but not for other things. I mean, for example, when I was very actively involved in reforming law for women around domestic violence, around violence against women and girls, against forced marriages or female genital mutilation, all the ghastly things that happen to women, you know, fatalities, murder. When I was looking at all of this and rape, I looked at other jurisdictions, met with lawyers from other jurisdictions, and I have to tell you, this is a problem for women everywhere. So don't think there's any great place for women. Women do not get a good deal out of legal systems because, by and large, legal systems were not made by women. They did not have a part in it. And their absence from the creation of law means that most law was made from the perspective of those who had power and who tended to be men. So we're evolving law. And so the problems exist in most systems. And so I can't, to your questioner, I can't point to anywhere that I would say is the perfect system, although I think that Canada is pretty good. I think Canada is one of the places. New Zealand's pretty good.
Yeah, but I would say also that the same problem exists. You know, legal aid rates have been going down, I think, since in real terms since the early 90s, right? Mm-hmm. So these are problems which are which I think are pretty common across the common law jurisdictions. And I couldn't speak to who's doing everything very well. To the second question on a rebrand. That sounds so gaudy to put it like that, doesn't it? But there's a point here that I was making earlier on something to be proud of. And I mean, this is a country that had a special mass celebration for a public institution in the NHS. And as, fine institution, I'm sure, but there's a hell of a lot better public health systems out there if you want to look for them, and maybe this was one of the first. But I would say that its record in establishing a legal system to be proud of and then exporting that model to much of the rest of the world is something that should be much more proud of. I'd much rather see a mass said for the legal system than for the NHS. I mean, maybe
I'm not going to let you just get away with this. It was being the purpose of their being was to celebrate the people who, coming through COVID, had basically gone in there day in, day out and had to deal with high numbers of deaths and members of my family were involved in it, and I'm not having it suggested that having a mass in favour. It wasn't for the institution so much as for the people who make the institution work.
But we will say that even before COVID, this was a very venerated institution. Rightly or wrongly, it is a deeply venerated one, as are the people in it. And I'm not suggesting we're going to get to the point where lawyers are clapped outside on a Thursday, and I don't think we'll ever get there.
I don't think we will.
There is a point that the country is quite capable of admiring and venerating its institutions and being proud of them and creating a mystique around them and a sense of national pride. And really, if you compare the NHS to a great many other public health systems, it doesn't necessarily stack up all that well, but you're still
We're not going to get into an
argument
about why that might be and who might be responsible for that.
Fine, I don't want to get into that point, but my point is, if you're perfectly capable of venerating one particular public institution, even before COVID, then why not the legal institution? Why not the legal institution, the legal frameworks that have been so successfully developed and exported from this country?
That's a classic conservative way of doing things. You can only raise up one thing by pushing another thing down.
I'm not saying push it down.
No. Let's. Why could you
Here's
say?
a case study.
Wouldn't it be great for us to have?
Let's move to the next
Sorry,
one.
sorry, could I just add something a bit different on this as well? And yeah, the idea of veneration sounds a bit. Well, not so sure about that, but anyway. But could I just say, and I suppose I see it from the point of view of my firm, which has offices in all sorts of different places, and actually we've struggled for a long time in getting lawyers, particularly in many continental European countries, to do pro bono in the same way, but actually for a really good reason, that it was still seen as the duty of the state to ensure that people had access to legal advice. And that is a completely different system, but still works better, so far as I can see, for the mass of people, for people, for regular people wanting to get legal advice to get on with their lives. So, so again, I'm not quite so sure I would be in the business of saying common law and the rule of law, it beats everything. I think there's a lot to learn from these different systems. So I think it's a good question for that reason.
Let's go to a question at the back there, right at the back, in the corner, if we can. We've got a few minutes, so if you can ask this one quickly, we'll try and get this one and maybe one other if we have time. Thank you.
Cheers for that. You mentioned about school education systems, about learning the law, teaching the law to younger generations and that. But do you really care about the younger generations and that? Because I feel like the many questions about children in general, about what they've been educated about, being inspired about, like for instance, about not being rude to the LGBT community. But what was that about? There's certain things that children can know what to learn about, and I believe, as I mentioned before, children are the new generation of today tomorrow. We're going to be dead by tomorrow, you know what I mean? So they're going to take over. If you do want this law to exist, take into consideration about them. What's your opinion about that? I mean, yeah, every day the law is changing. We're learning new things and all of that. But that's it, really. And also about, what you mentioned too about you mentioned too about a lot of things. But so answer that question first, then I'll come back to you.
Yeah. So the work that the Public and Youth Engagement Programme at the Bingham Centre was engaging with was having some very complex legal concepts taught to relatively young children and young people. And we found that they had a huge capacity to be able to think about these issues. And from stop and search as a teaching point for where young people from diverse communities might experience arbitrary interactions with the state, to thinking about how the family structure is impacted by the law. These are things that children have already experienced that are really great jumping off points for engaging in some really high profile and important discussions of public policy. So I think I would somewhat question the premise that young people aren't ready for challenging conversations. As a citizenship teacher, I found that they are, and we often believe that there is a sort of difficulty in teaching young people that actually isn't there with complex topics. So with colleagues at the UCL Institute of Education, we've been working with equipping PGCEs, that's trainee citizenship teachers, with the ability to teach the rule of law, and they get it. Their students that they're training as trainee teachers get it, and they're teaching in some really difficult urban environments. So they're ready for the rule of law. We just need to have the resources to be able to get it to as many schools as possible, and we'll have a national next generation of people who are equipped with knowledge, skills and confidence to deal with legal issues in their lives.
Thank you. Let's just get one last one. If we can get to the front here. Thank you.
Hello, good evening. Thank you. My question will be to Baroness Helena. My name is Wachtang. I was litigant in person in two claims. First was judicial review when I have protected my position, and it was proved that unlawful action of the Minister of the Home Secretary. However, judiciary system tried to protect, in my view, the executive, considering the case as academic. And I would like to clarify to the public, academic means claim is settled. And second claim was based on the human rights claim, Article 8, compensation of the damages based on the judicial review. It was in the High Court of Justice. It was a private law claim where I was also litigant in person. I did both cases alone without any lawyers.
For that you deserve a prize.
Thank you. I have used pro bono service. However, I have my opinion that not always they assist in position of the claimant. But my question is, I was born in South Ossetia, which is part of Georgia, and the same story, what happens now with Ukraine, happened with that part of Georgia. In the High Court claim, I had a chance either to negotiate with the government legal department who was defending the Home Secretary under Part 36 offer and settle the claim, or to continue and create the law, which is important for me and for the public.
Can I just, this is too complicated for...
Yes, my question
to you... It's too individual, it's not a general question.
My question to you is Crown above the law?
Well, the Crown should certainly not be above the law, and the Home Secretary should not be above the law. And in matters to do with immigration, and you haven't indicated what the nature of the case was. Was it an asylum-seeking case? It was an immigration case?
Yes, it was original immigration.
An immigration case. The whole point of the system, and it doesn't operate in totalitarian regimes, is that we have a system whereby we can, through judicial review and so on, challenge decisions that are made as being ultra vires, or, we can challenge decisions that have been made by government ministers and government departments. And I don't know whether the finding in your case was fair or not, but it seems to me that that is one of the fundamental things about a decent democracy, is that you are able to challenge government, that you can take government to court. And no, the Crown, we call it the Crown, the state basically should never be above the law, right? And it sounds to me as though you feel that in this case it was above the law and that the judges found in a way that you thought was unfair. There will be cases where judges make decisions that one side or the other finds unfair, and sometimes it's the state, and sometimes it's the applicant, yourself. But I'm not going to retry it here. I'm sorry. Okay, but I by and large, I've been involved in cases where I've been disappointed because the decision in the end has gone in a way that I didn't like. But I think that that's one of the problems, and I think that in immigration just now, a lot of unfairness is taking place. So I think that's enough, if you don't mind.
Thank you. Well, guys, you may have other opportunities to ask questions now. I think we're going to finish, but you may be able to grab some of these panelists to chat privately. Apologies we couldn't get to everyone, but it's been a really fantastic panel. I think you'll all agree that these guys have been really interesting, very informative, and that we all have a role to play in this. So I hope it's been useful to you too.
It looks as though there's a whole set of people who are going to become great lawyers, and that's what we need. We need new great lawyers to come and join us in the profession. Yeah?
I'm sure we all want to thank this amazing panel. We've had such a lively and thought-provoking discussion. If you want to read more about some of the threats to the rule of law and some of the possible solutions to build on what we've heard today, whether that's talking about the current threats, whether that's solutions such as a justice bus, or whether that's political changes, there is this really detailed report that Paul referred to earlier, Justice produced earlier this year, called Threats to the Rule of Law, or something to that effect. If you Google Justice Rule of Law report, you'll find the report and you can download it and read it. If you've been compelled, if you're a lawyer, to want to volunteer pro bono to make a difference by giving free legal advice to those in need, if you go to the Pro Bono Week website and click on volunteer, and we have lots of links to places you can volunteer. So there's one final plug from me. If you like carols and you like pro bono and you like mince pies, do go along to the Carols for Pro Bono on the 14th of December. It fundraises for two really important pro bono charities. So with those few plugs, thanks again to Paul and our panel for this fantastic debate tonight.